Welcome to Your Strata Property, the podcast for property owners looking for reliable, accurate, and bite-sized information from an experienced and authoritative source.
Hello and welcome. This is the podcast where we cut through the strata jargon so you can live and work a little easier. I'm Amanda Farmer, strata lawyer, and you'll often find me sharing my thoughts on strata law and strata living with the Australian media. Most recently, I was quoted in a story that appeared on 9.com.au about the rise of renting out unused car spaces. Apparently, some people living in our CBDs are pocketing up to $850 a month renting out a car space that they are not using. Sounds like a pretty easy side hustle, yeah? But as I told the journalist for that article, behind the headline are a few traps for the unsuspecting, especially when it comes to strata properties. So today I'm going a little deeper than that news story, though if you do want to have a read of it, there is a link to the story in the show notes for this episode. I'm going to walk you through what you need to be aware of if you are thinking of making some extra cash renting out your strata car space, because nobody likes receiving bylaw breach notices, having to pay penalties, or even having an insurance claim rejected. Best to go in with your eyes open. I'm going to share some real-world wins for strata owners involved in protracted legal disputes about parking, and I will give you access to my cheat sheet of important legal cases on strata parking. And if you're a strata manager or a committee looking for some tips on how to stop the practice of residents renting out their spaces to non-residents, you might find some of those tips hidden in plain sight in this episode too. So let's dive in. First up, we need to start by establishing some simple facts. Who really owns a car space in strata? Is your space common property or is it lot property? Some of you might have enclosed garage spaces. Some of you may have a bay in a basement parking area. For some of you, it might be open air parking. It might be a carport. Now, hopefully, if you are an owner, you will know the answer to the question of whether or not you actually own your parking space. If you are the legal owner of the parking space, it's going to be on your title. You will have purchased it either as part of your residential lot or perhaps a separate lot that you purchased together with your residential lot. Or if your space is actually common property, it might be that you just have a right to use it. That right could be under a common property rights bylaw. Or maybe this right to use a common property parking space is a right that's available to all residents in the building, maybe on a first-come, first-served basis, scramble parking, as it's called in some of our older blocks. There might not be enough parking to go round. And boy, does that cause some problems in those buildings operating with those regimes. So if the space that you're using for your parking is actually common property, you are going to need the owner's corporation's consent before you do anything else with it, before you legally lease it to somebody else. Only an owner's corporation can approve the leasing or licensing of its common property. So this is certainly not a situation where you can just list it and start bringing in the extra cash. Now, while we're talking about bylaws that grant rights to use an area of the common property for parking, I want to share with you the Veney case. That's Veney, a case from our New South Wales Supreme Court in 2020. This case involved a block where everyone had their own car space on title, but when anyone parked in car space number 51, it made it very difficult for the residents using the adjoining spaces to park their cars. They had to do a couple of extra manoeuvres. Sometimes there was a bottleneck of cars waiting to get in or out. And the problem was made worse by the existence of a rockery, which was on common property. Now, trying to solve this access problem for car space number 51, the Owners Corporation made a bylaw allowing the owner of Lot 51 to use an area of the common property for the purpose of parking their vehicle. Now, Mr. Vaney bought into the building. His lot came with car space number 51, and he started to use both the car space, 51, and the allocated area of common property under the bylaw. Now, other owners saw this, complained about it, thought Mr. Vaney was a bit greedy. How is it that he can use now 2 car spaces? And their view was that Mr. Vaney's right to park on the common property was actually in substitution for his right to park in his space, number 51. He couldn't use both spaces. And it was also alleged that by continuing to park in space number 51, Mr. Vaney was causing a nuisance. He was causing that bottleneck. He was making it hard for others to get in and out of their spaces. Now, before the Supreme Court, Mr. Vaney said that on a plain reading of the bylaw, there was no substitution. He could use both spaces if he liked, and also he wasn't the cause of the nuisance. The real issue was the existence of the rockery on the common property. He said the rockery should be moved if other owners wanted to access their own spaces while he was using his space 51. The Supreme Court agreed with him, holding that the bylaw allows him and any future owner of his lot the right to park on the common property as well as in his space number 51, and that mere inconvenience for other drivers was not a nuisance. Pretty good result there for Mr. Vaney, 2 for the price of 1 with those car spaces. That's what can happen when bylaws are drawn up that grant these incredibly valuable rights. Other owners might have thought when they approved that bylaw that they were being kind, they were being sensitive to the situation. For the owner of 51, they couldn't get in and out of their space. Let's give them a different place to park on the common property, not realising that they were actually gifting them a second space. I can only imagine the legal fees that were spent on that dispute. Lesson is, wording of these bylaws is important. So if you are using an area of the common property to park your vehicle, and if there's a bylaw that regulates that, make sure you're aware of it, especially if you're thinking about leasing out that space to somebody else. Now, even if you establish or you know that you own your car space, that it is legally on your title, there is no common property rights bylaw to worry about. Don't stop there. Do go ahead and check all of the owners' corporations' bylaws. Even if there isn't a bylaw that's specific to you and where you park your car, it is possible that your owner's corporation has a bylaw restricting the way you use your car space. There may even be a bylaw saying that non-residents can't use spaces. I've certainly seen those before. I do think that that kind of bylaw might be a bit tricky to uphold if it is challenged. And I'm reminded of another rather famous case in our strata circles, a Court of Appeal case from New South Wales. We always like those when we get to that level, the highest court in our state. This is the Canny case, Canny 2018 case. This involved a building in Elizabeth Bay where some residents had actually sold off their parking spaces. So this is a setup where the parking space is actually a separate lot. There would have been owners in that building that bought both their residential lot and their car space lot. Because they are on 2 separate titles, the owners can separately sell their car space lot. They find they don't need it, they want to make some money. That had been happening in this Elizabeth Bay building. And there were a lot of people who didn't live in the building but owned a car space there and parked there regularly. No doubt some of them too were leasing out those parking spaces. These people are not residents in the building. At the time of the court case, these parking spaces were selling for up to $200,000. So a significant investment for those people who were buying in, just buying the parking space, not living in the building. A number of years of this buying and selling of car spaces happening, the owners' corporation decided that only a resident was allowed to own a car space, and they made a bylaw to that effect. The investors who only owned car spaces were technically in breach of that bylaw. They challenged the validity of the bylaw. It went all the way to the Court of Appeal, and the court found that the bylaw was invalid. Owners of car spaces had a right to use their car space whether or not they were residents. An owners' corporation could not prevent access to property in that way. Nor can an owners' corporation restrict leasing. So returning to the context of today's conversation, if you own your car space and you want to lease your space out to a non-resident, a bylaw that prevents you from doing that, I think it would be invalid on the basis it is a restriction on leasing. In New South Wales, our Strata Schemes Management Act expressly provides that an owner's corporation cannot make a bylaw that restricts leasing. So while it's a good idea to go and check, number one, that there's no common property rights bylaw that might relate to where and how and who parks on the common property. Also check that there aren't any bylaws restricting owners from leasing their car spaces to non-residents. I've said I think those kinds of bylaws might be invalid, but do you really want to end up in an expensive legal fight with your owner's corporation? Probably not. Not for your $850 a month. That's going to disappear pretty quickly once strata lawyers are involved, I can tell you. Now, there might not be a bylaw that expressly prevents you from leasing your car space, but what about a bylaw that limits access or makes it very hard for non-residents to access a building? These bylaws are often made in the name of security and safety for a building. I'm talking about bylaws that regulate the number of keys or security fobs, swipe cards, passes that a resident may have. Those kinds of bylaws are really common, especially in our more modern buildings with electronic access systems, buildings with basement parking, buildings with boom gates. It's not uncommon for me to see bylaws where the owner's corporation caps the number of keys or fobs that a resident can have, depending on how many bedrooms there are in their apartment. 1-bedroom apartment, 1 fob, 2-bedroom apartment, 2 fobs. If you're a couple, then you're going to need those 2 fobs. If you're thinking about renting out your space to a third person, they're going to want a means of getting access to your space. They're going to need a fob. Will the owner's corporation allow you to have 3 active fobs? Now, if the person you are leasing your space out to cannot easily or reliably get access to that space, you are going to have a problem. There may be some other rules where guests or visitors have to report to the building manager or the concierge, making it really hard administratively for you to lease or sublet your car space by limiting the keys you have or imposing these kinds of registration rules on you. It really is a de facto restriction on leasing your space. And I think it's a pretty effective one. As I said, these rules, these bylaws are made in the name of security. Really proactive buildings are regularly auditing their fobs and their keys, requiring residents to hand in the devices they have, resetting those devices, making sure only current residents are holding devices. You're going to be in a world of pain with that person who is renting your space if they are not able to get access when they need to, or their access is suddenly and without notice revoked. And just by the way, tenants, as opposed to owner-occupiers, tenants are going to need the consent of their landlords before they can sublet any part of the property, including a car space that is part of the property. So landlords, one way for you to be aware that this is going on, that your tenant may be subletting a space to somebody else, which may or may not matter for you, but one way you might be tipped off to that going on if your tenant has not sought your permission is that you might realise your tenant has applied for 4 keys or 2 new fobs. Check in with your strata manager about how many keys your tenant has been requesting, and that might help you prompt a conversation with them about exactly what is going on at the property. Now, finally, I want to make sure I touch on some risk management issues here, including insurance implications and potential tax consequences. Your home and contents insurer, or if you are an investor, your landlord's insurer, really should be told if part of the property is being leased or subleased, including a car space. There may be a standard policy exclusion where a property is being put to commercial use, or it's considered that there is a business that is being operated from that property. Without that disclosure, claims, should they be made, may be refused. And it's just so important when you've got somebody else regularly using your property or part of your property that you are covered for any loss or damage that may arise from that use. So this is a good reason why a landlord needs to be aware of who is using their property and even if you are an owner-occupier, make sure you have put your insurer on notice that you are leasing out a car space. Now, I'm not a tax professional, and I certainly don't give legal, financial, or tax advice here on this podcast. But just a heads up, it is very likely that income from leasing a parking space is going to be assessable for income tax purposes. Have a chat to your accountant, your tax advisor. Make sure you're up to speed on that. You want to be keeping records, dates, payments, terms of any lease or license arrangement at tax time. You probably want to be declaring this income. Don't bury it. That's not going to be a good policy. And if you are, having listened to this podcast, maybe got some ideas here, you've checked the bylaws, you're thinking this is something that might work for you, you're going to go ahead with a bit of a side hustle, get a simple lease agreement in place. Something that's only 1 or 2 pages can save thousands of dollars in misunderstandings. You want to include the parties to that agreement. That's the owner of the property and the name of the person who's going to be leasing that space, the lessee or the tenant. You want to identify the part of the property that they have access to. Is the car space marked with a number? Where is it located? Is it the whole garage? Is it just the space between the lines? What level is it on? What's the term of the lease? What's the rent? When is it due? How is it paid? How does the tenant get access to the property? How do they get a fob? Is there a bond for that? What happens if that gets lost? Are there certain times that they can get in or out of the building? Make sure you cover off liability. Who pays for damage? Who is responsible? What if their car gets damaged by someone else? What if for some reason their car gets towed or moved by the owner's corporation? Who is responsible for that? And what happens if there is a dispute? Is there a dispute resolution process? Do we go to mediation? Do we end up in the tribunal? How does that all work? Things to think about. I wouldn't be a lawyer if I wasn't reminding you of those. And here's a bit of a tip. If you are going to be renting out your space to somebody who is not a resident, give them a copy of your building's registered bylaws so that they can read them too. They're in the loop on them. I suggest this short 1 or 2 page lease has a clause in it that requires them to comply with those bylaws so far as they are relevant. Setting these clear expectations from the start can avoid a world of hurt later, both for you and for your neighbours and everyone else in the community. So if you're sitting on an empty parking space right now, looking at it and seeing dollar signs, here's your quick action checklist. Check the title. Do you own this space? Is it part of your lot or is it common property? Scan the bylaws for any rules or restrictions about parking, the use of parking spaces, the leasing of parking spaces, and any rules about guest access and non-resident access to the building, as well as limits or restrictions on the number of keys or fobs for residents. If you do need the owner's corporation's consent, either because you're looking to use an area of the common property or the bylaws require you to get that consent, make sure you seek it, obtain that consent. A meeting may need to be called. Motions may need to be put forward for approval. Call your insurer, make sure you're covered, get that in writing, and set up a clear, straightforward lease or license agreement, including at least the essentials that I have covered off here today. Now, if you're interested in this topic of parking in strata, if you liked hearing about those couple of parking cases I've shared here today, there is more where that came from. Last year, I spoke to Radio National about parking in strata more generally. And for listeners to that program at the time, I put together a resource summarising some of the most interesting, I'm going to say, parking cases from around the country, not just New South Wales. That resource, it's a 2 or 3 page PDF, is still accessible completely for free. You can get your hands on it over at yourstrataproperty.com.au/parking. If you want to grab a copy, head there. That link in the show notes for you as well. Thanks for tuning in this week. If you have questions or a parking side hustle story, I would love to hear from you. Go ahead and post a comment under this episode over on the website. Enjoy the rest of your week in strata. I'll look forward to catching you next time. Bye for now.
Thank you for listening to Your Strata Property, the podcast which consistently delivers to property owners reliable and accurate information about their strata property. You can access all the information below this episode via the show notes at yourstrataproperty.com.au.